Recording in progress.
Oh, great. Judge McHugh, would you turn on your camera? We're having some video difficulties. I want to make sure you're seeing the lectern and the other two judges.
Yes, I see both of those.
Okay, and then do you see the timer? The
on the bottom right of the screen?
Yeah, it's a little cut off, but I can see it.
So let's,
And now I can see it.
Can she go off video?
all right. So do you still see the two
Lectern?
views on the screen?
Yeah, right now I just see myself,
Okay.
which I'd rather not. There I go. Now I can see what I need to see.
Okay, so then you should be set and you can go ahead and hide yourself.
Go off. Okay.
Judge. Okay, so we're good to go now.
Oh.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning, everyone. We have a full day. We have 6 cases for decision, 5 of which will be argued. And we have Judge McHugh over my shoulder, which is a good place for you to be, looking over my shoulder, Judge McHugh.
Your guardian angel.
All right. She would be here, but events beyond her control have her on our television. We're grateful for Zoom. Seated next to me is Judge Brattle from the District of Kansas, and the 3 of us together will be your panel. Before we get started with the first case, Ms. Castro, I understand there's preliminary business.
Good morning, Your Honors.
Good
I
morning.
have a preliminary motion to admit 2 new members to the bar of this court. Before making this motion, with your permission, I'll introduce the candidates and ask them to approach the lectern. So first we have Caleb O'Quinn. He is a graduate of Harvard Law School, a member of the New York Bar, and law clerk to Judge Brow. Second, we have Sophie Leonard. She is a graduate of the University of Kansas School of Law, a member of the Kansas Bar, and law clerk to Judge Brow. Before I move for their admission, are there any questions for our candidates?
I have a question for the first time ever. And when we sat with Judge Gorsuch, he would sometimes ask a question. And I came across something interesting that nobody may know, but if either of you know, there might be a bonus prize in this. What is the only place on the Constitution that has a smudge?
I would guess the signatures, Judge.
Well, that's a great guess, and we may have some sort of a consolation prize. We'll see. But the answer is that it went right up to the wire. George Washington, who commanded the respect of everyone, and his word was kind of law, there was a dispute about how many citizens for a representative, big states versus little states, and it looked like the whole thing might crash when it went out for ratification, and they changed the number. And it was at his beck and call that they changed it. It still wasn't enough, that it wasn't a big issue, but I've only seen the Constitution once. Next time I go back to see it, I'm going to look for that smudge, and that's the last time I'll ever ask a question. Thank you, Ms. Castro.
Thank you, Judge. I respectfully move for the admission of these candidates to the Bar of the United States Court of Appeals for the 10th Circuit.
Very well.
Would all members of the 10th Circuit Bar please stand silently and renew your own admission oaths? Candidates, please raise your right hands and repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that I will conduct myself as an attorney
that I will conduct myself as an attorney
and counselor of this court,
and counselor of this court,
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and I will support the Constitution of the United States.
Congratulations.
Congratulations to both of you, and welcome to the bar.
Thank you.
All right, our first case for argument this morning is United States versus Orrantia. And counsel, we're ready for you when you're ready to present. Yes, please.
May it please the court. My name is Brock Benjamin, and I am here to represent Oscar Orrantia. Before I begin, I have two preliminary matters, one of which is I re-urge my hope that I have every time I'm here to reserve some time for rebuttal, and I will do my best to do that. But the second, Your Honor, is I have advised the United States. My reply brief, Your Honor, I think was a little ambitious, and the first issue in my reply brief, I think, violates the cardinal rule of not raising an issue in a reply brief. And so I've notified the United States, Your Honor. Having said that, I'm going to begin with issue 3, which is the deprivation of the video. Port Director Tony Hall was a witness who
Before you start, I know which issue you're abandoning. Is it the argument that Section 1519 is unconstitutional as applied?
No, Your Honor, that is the count 2 had insufficient evidence, and the non-unanimity instruction is structural error
Okay.
in the reply brief,
Thank
Your Honor.
you.
Thank you. Director Hall annihilated Oscar Orrantia, and this was mainly because, I would like to say my close friend, Marissa Ong, is a very advocate and strong advocate, and the government, used him as a sword and a shield. Director Hall's testimony and participation falls into 3 of the issues that Oscar Orrantia is appealing. I had filed a motion for remand, first time I've done that, and I had attached an Exhibit A that discusses the June 4th, 2020 incident with witness 2 or Baron. And Hall and the video, I think and can argue, are exculpatory. And I had asked for a remand. That didn't happen, Your Honor. We're here. The United States has responded. And I'm wondering if I proceed on that, Your Honor, or if the court has any guidance for that.
No guidance, just please proceed.
Thank you, Your Honor. And Your Honor, at this point in time, I think, and having briefly discussed this with the United States, I think that's almost fully briefed. Port Director Hall stated that in that letter states that he reviewed the video of the incident and was unable to hear the comments described by Mrs. Baron. He stated that he observed the use of force as applied by Officer Orrantia, and Orrantia was not disciplined about that. Additionally, he says that when he talks about the badging incident, as the United States mentioned it, he says that Orrantia was non-compliant. This is, I think, central to the idea that the United States uses Hall and argues in a different issue that there was a specific contradiction. However, this testimony shouldn't have come in without the video that was destroyed. And if we look at the timeline.
Did the defendant open the door by testimony and direct out?
Your Honor, I don't think so. And Joe Shattuck, the defense counsel, specifically said Oscar Orrantia, and the letter, that Exhibit A, says that he was non-compliant. There's nothing about dishonesty or that he was disciplined for that. And so opening the door is always a careful line that counsel walks, but.
Are we talking about Director Hall?
Correct, Your Honor. Director Tony Hall. And so, Your Honor, I would suggest that no, because I think it was those issues and those impeachment issues, and I've referred to them as the 404B issues. The court goes back and forth, and I think the government clearly intended to argue them as 404B from its briefing and its argument during trial. But the government used the Baron and Tony Hall incident as a sword and a shield, where it chose, and the government had stated that we did not charge this incident, and frankly, the reason we didn't charge it because we didn't have a video like we do for the incident with John Doe. And if the court will recall, that incident with John Doe was a year prior to the incident that they don't have the video with. But so they're able to argue.
But there hadn't been criminal proceedings against your client yet, right?
Correct, Your Honor. There had been no.
And so they tape over every 90 days, correct? As a matter of course.
That was the testimony, Your Honor. The issue here is that they produced some videos and not the video with Baron. And so the United States came in and said that we don't have that video, but yet we're going to say that this incident happened and leave an impression that, quite frankly, Mr. Orrantia was probably charged in a separate incident or something out of that, when there was no discipline that was imposed by that.
What is the answer to Judge McHugh's question as far as 90 days? You said there's testimony. We take that as so, don't we?
Your Honor, that comes from Director Hall, but I think that testimony and the writing over of the video, Your Honor, I think is something that goes into the good faith, bad faith trombetta argument as to whether or not they should be able to use that incident with the video. If they taped over it, the CBP is still the government.
Well, if it's a 90-day policy and there's only so many tapes or whatever else, how is that bad faith?
Because we still have the video from the initial incident, and we have Your Honor, in that video, we only have that because of civil litigation. And so if we're preserving some videos for civil litigation, but yet we're going to pick and choose the videos, I think that is, I think that, Your Honor, that's something that I think as a defense attorney, that's something that bothers us, because it does, I think, go into that.
Doesn't that really support the government's position, though, that they were preserving it because of litigation and routinely destroying things they didn't need for litigation purposes?
Yes, Your Honor, but then the argument is that then they don't get to use the other incident, imply that he was disciplined, and not have the video that that they had reviewed and decided not to discipline Oscar Orrantia on.
So, and just so I can clarify, he was not disciplined for any of the prior incidents, right?
Your Honor, and I have to split that.
Or subsequent.
Because of he was not disciplined for the 2 use of force incidents that were brought in by 404. And the Badon incident is the one that is a year later that he was not disciplined for. Yes, Your Honor.
And I couldn't find any evidence in the record where that was elicited, the fact that he was not disciplined.
Your Honor, it's my understanding that they were essentially told that all they were going to be able to bring in was the 404B issue and not go into, for lack of a better term, administrative matters. But the issue is that leaves the hanging fruit out there that it's an implication a jury is going to draw, I believe.
Well, let me stop you there. You argued Trombetta. For that to even apply, we have to know that the video would have been exculpatory, and we don't know that. So it seems to me that you're under, if anything, you would be under Youngblood, which would require a showing of bad faith. And I just don't think you have that here.
Your Honor, respectfully, I would suggest that we're under Trombetta because the issue here was the government argued that they couldn't hear things on this video. Director Hall couldn't hear things on the video of Badon, and so that would be exculpatory because it would directly contradict and lead to the Brady language is what comes to mind. It would lead to a suggestion that there was less culpability than what was suggested by the government.
Well, he said he couldn't hear it. He didn't say it wasn't said. I mean, we watch a lot of videos, and there's lots of things that you can't hear.
And the government in count 2, Your Honor, argued that Mr. Orrantia, or Officer Orrantia, was making false representations because they couldn't hear things. It's the same exact couldn't hear statement or couldn't hear type of testimony that was being alleged. The issue 1, Your Honor, sufficiency on knowingly making a false statement. Jackson versus Virginia says that reversal is needed where no rational jury could find beyond a reasonable.
Well, let me stop you there. I think you've got a preservation issue with this particular claim. In the district court, you didn't argue about whether he knowingly made the statements. In the district court, you argued that there were no false statements made at all. It seems to me that's a different argument on appeal. Why should we consider it?
Your Honor, in direct response to the fact that knowingly was not raised as part of the Rule 29 argument, I would point the court to page of the record, volume 4, 686, where Mr. Shattuck says, I would submit to the court those issues are not falsifications but omissions, and the government then specifically in the conversation moves to whether there was knowingly falsified or made a false entry in a record or document. I think that was the heart of Mr. Shattuck's argument. And so that goes back to the...
Well, that's what the government said. What did you argue? The district court didn't rule on that.
Your Honor, I think the district court ruled with the government and suggested that because they'd argued it, they supported the knowingly. That was Mr. Shattuck's, the heart of his argument. He didn't use the word knowingly, and respectfully, I don't know, is to argue the mens rea, one has to use the term knowingly, but that Ms. Ong jumped on that because that's what she understood Mr. Shattuck was raising, is the contention. And in the falsification there, I cut and pasted many of the statements for Mr. Granillo, pulled his shoulders back and struck out his chest towards me, which is the statement in the report. The government argued that Director Harvey testified you can't see that in the video. This was because the examples that I placed at page 29 in the brief are that the United States offered as examples of falsifications. How are they? They show that they're not by definition false, but they're either omissions or misleading. And Agent Ramos, even for the government, even testified about perceptions and the dark video. Further, Director Carmen discussed the report with his supervisors, recommended discipline, was told not to impose it. And so these are all, I think, facts that go directly to the idea that these were just blatant knowing misrepresentations by Agent Orrantia, as opposed to these were things that were, I think, very effectively argued by the United States. But I don't think that gets us past the idea that what you can convince a jury of legally binds this court or the district court or this court to find that those were sufficient or that they were proper and the she didn't go out, or the government didn't go outside of where they were at with regard to the mens rea. And issue 2, Your Honors, I would suggest is also preserved, because that's the same exact quotation for Mr. Shattuck, Volume 4, 685 to 687, where he states, I would submit to the court that those issues are not falsifications but omissions, and then the response from the government is that those are knowingly made and not omissions or anything else.
Counsel, I will alert you, you're at the point where you said you wanted to reserve for rebuttal. It's your choice. You can continue to go on. I'm just providing you that as a courtesy.
Thank you, Your Honor. I appreciate that. Does the panel have any questions based upon where I'm at this point? Thank you, Your Honor. May I reserve the remaining time?
Yes.
May it please the court, counsel. I'm James Braun on behalf of the United States. The defendant raises, by my count, 7 issues, 5 in his opening brief and 2 more for the first time in his reply brief. He's withdrawn one of those, but we would argue that all but one of the arguments he raises should be considered waived. The first 2 issues, sufficiency of the evidence on count 2 and the as-applied constitutional challenge to section 1519, are waived because they were not raised below, and the defendant fails to argue plain error on appeal. Now, to follow up on Judge McHugh's question about whether this was preserved, the knowingly sufficiency argument, that simply was not the defendant's argument below. What he argued is that the evidence proved only that Orrantia had omitted information from his report and that those issues were not falsifications. That's Appendix 4, page 687, or sorry, 686. That has nothing to do with knowingly. He didn't use the word knowingly. That was not the issue. And even if it was preserved, this court can easily conclude that the evidence was sufficient on the knowingly element. This isn't a case where information was relayed to the defendant and then he wrote it into a report so he could argue, well, I didn't know it was false, I didn't even see it. These were actions that he committed himself, things that he observed himself. And the government established that he had a motive to falsify the report, to cover up for his unreasonable use of force. And so that simply wasn't even an issue at trial, and this court can easily dispose of that issue. Now, in his reply brief, the defendant seems to expand on his sufficiency argument by raising, again, for the first time, a challenge to the deliberate ignorance portion of the jury instruction defining the word knowingly, and that's instruction 24. That he has not withdrawn that argument, and it didn't come up during his opening argument this morning, but it's important to point out that, under Lafler, this court generally doesn't consider issues raised for the first time in a reply brief, and it would be especially inappropriate here because, aside from being improperly raised for the first time, any possible error in this instruction was invited. This exact instruction was contained in the parties' joint proposed instructions. The defendant didn't include that in his appendix, but that's document 97, instruction 8. And during the instructions conference at trial, after going through objections to other instructions, the court asked if there was anything else on the proposed instructions from the defense. And defense counsel responded no, and he acknowledged that they had agreed to these instructions, which would include the instruction that had that deliberate ignorance portion of the knowingly instruction. And so we would argue it's invited error, if anything. This court shouldn't even consider it under Lafler. And then finally, it's just perfunctorily briefed, and it's another reason not to consider it for the first time in a reply brief. Now, moving to the next issue, the defendant argues that the cumulative effect of Rule 404B incidents was unduly prejudicial. This issue is waived because it's the defendant's burden to point to where in the record he made a cumulative 403 objection. He hasn't done that, and he doesn't argue plain error. But it's also without merit, because only 2 of these incidents were actually introduced under Rule 404B. And the court did do a proper Rule 403 analysis as to those incidents. The other 2 incidents were introduced to impeach the defendant after the defendant testified.
Can I stop you there?
Yes.
Because you just touched the issue which is of most concern to me. It's not 2 questions. One is, how did Director Hall's testimony actually impeach what defendant testified to? And when he offered the opinion, basically, that defendant is a liar, how is that harmless error, especially on count 2, where the issue is about his intent and knowing falsification?
Well, Judge Rattle, if you look at the defendant's testimony towards the end, the defendant is affirmatively asked about this girlfriend incident, as we've called it in the briefing. And he affirmatively testified that he had permission on a prior occasion to have his girlfriend visit, and that he assumed he had permission on this occasion. That's at page 898 of the appendix. So that's something that's brought up by the defendant on his own. Now, at that point, as Judge Phillips noted, that's opening the door to questions about that incident. It's opening the door to affirmative evidence about that incident, totally aside from impeaching him with, that he's lying about that during his testimony. So this evidence does both. It affirmatively responds to something that he opened the door to, and it impeaches him because what Director Hall testifies to is that, no, his investigation revealed that the defendant had not had permission on a prior occasion, and so therefore that's being untruthful. And that was proper impeachment of the defendant's testimony that he did have permission on a prior occasion. So for both of those reasons, this was proper. The defendant opened the door to it by testifying to it on direct, that exact incident, that exact issue relating to that incident, and it impeached him. And that's really all Director Hall testified to. He didn't testify to anything about the charged incident. And so to the extent that...
Well, the court let that incident in under 608, right?
The court said it introduced that evidence for 2 reasons. One was 608, and one was impeachment, which we're arguing is proper as under the doctrine of specific contradiction, contradicting what the defendant testified to.
Okay, so you concede that that you can't use specific incidents of extrinsic evidence on a 608.
Right.
Under 608.
That is true, but there's the independently sufficient reason that the court also cited, which was impeachment, which would be this court's doctrine of specific contradiction. The defendant hasn't addressed that at all. And so under this court's case law, by not addressing an independent sufficient reason, it's either waived or the defendant just has not addressed it.
Well, and he didn't raise the 608 issue until the reply brief. Am I right? In the opening brief, the only argument was under 404.
Well, that's under
404
when he's arguing
403.
Right, when he's arguing the cumulative 403, cumulative prejudice. But he does raise 608 in a similar context as his final issue with regard to the Exhibit 31. But again, Exhibit 31 wasn't introduced. And even in his reply, the defendant still intimates or even explicitly says that it was introduced. It simply was not. The district court said, this isn't coming in, and it didn't come in. What came in was Director Hall's affirmative testimony about that incident and the discipline related to that incident. And so to the extent the defense is arguing that that exhibit was improperly introduced as extrinsic evidence under 608B, that's not accurate. It didn't come in for that reason. And now, when Director Hall's information originally came up, it was when the defendant was still on the stand. And so the idea of 608B was still a live issue. Whether Orrantia could be cross-examined with that information. And that would have been proper. That would not have been extrinsic evidence. Instead, the government didn't ask him about it on cross, asked about the badging incident that he had also raised, and then brought in Director Hall's testimony affirmatively. And at that point, the defendant didn't object on 608 grounds, didn't object in that regard. And so, it's waived, but we also just don't even need to go there because of the independent reason being the specific contradiction. And it did specifically contradict something that the defendant himself testified to. And if I could just have a moment, I had to cross out some stuff when I found out the defense was withdrawing the unanimity instruction argument.
So would you talk about the harmless error part?
I'm sorry?
Would you address the harmless error if Director Hall's testimony came in improperly?
Yes. It would definitely be harmless because he didn't testify again about the charged incident. And the jury heard a lot of evidence, saw the video of the charged incident, heard from Mr. Granillo and Mr. Granillo's, I think it was his wife's cousin. There was substantial evidence that the jury could base the verdict on for counts 1 and 2. Really, all Hall's testimony did was relate to this uncharged incident that the defendant himself had testified to, and it was certainly harmless in that regard.
Was Mr. Hall listed as a witness to testify to that before the defendant testified on direct?
I don't know off the top of my head if he was listed on the witness list or if that...
Does it matter?
It shouldn't matter, no. Because he ended up just testifying in rebuttal, and he rebutted that testimony that the defendant himself had put on. And so if anything, that just makes it more harmless, the fact that he was rebutting something the defendant opened the door to.
In rebuttal, meaning during the government's case or during rebuttal?
During the government's rebuttal. So the government had put on its case, rested, the defendant testified, and then the government called Director Hall in rebuttal after the defendant rested.
Understood.
Okay. Now, as far as the Trombetta Youngblood violation, as Judge McHugh noted, this is not Trombetta. The defendant, the best he can do is speculate as to what these videos would have shown. And so this is classic Youngblood, where the defendant has the burden to show bad faith. He has not shown that the district court clearly erred in finding no bad faith. And in fact, under this court's Smith case, destroying evidence pursuant to standard policy generally precludes a finding of bad faith in the absence of compelling evidence to the contrary. And the defendant points to no compelling evidence whatsoever. These videos were written over long before a criminal investigation of the defendant ever began. And as a practical matter, what we know is that Director Hall said that he saw the video, he saw the use of force, but he couldn't hear what was said. And we don't know why he couldn't hear. Was it because it was just fuzzy? There's, as Judge McHugh noted, lots of videos where you just can't hear what's going on. I believe the defendant himself testified to videos of other incidents where you couldn't hear very well. So that's not exculpatory in and of itself. He doesn't say why they couldn't hear, but he says he did see the use of force. But the defendant could have asked Director Hall about that when Director Hall testified. He made no effort to do that. He could have asked Director Hall, what did you see? What did you hear? He made no effort to do that. And so that undercuts any due process claim that the defendant makes on appeal. And unless the court has any additional questions, we would ask the court to affirm.
In this sort of circumstance, where there's been an allegation, can the accused obtain a copy of the video for his or her own purposes? In other words, anticipating this might be a problem, I want a copy of that video.
I would imagine that a subject could request a copy of the video, but I don't know for sure. I don't know how it came up in this case where the video of the charged incident was preserved. We know that Mr. Granillo went to the sheriff's department, made a complaint. He went to the hospital. The ACLU actually filed something, and I would imagine that's part of what caused this to be preserved, but it's not in the record how that played out or what the process would be.
Any further questions? All right, counsel, thank you.
Thank you.
Mr. Benjamin, you have some rebuttal time.
Your Honor, and let me address the court's last question. I don't know if it was asking if Mr. Granillo or if Mr. Orrantia could obtain a copy of the video. The way that I understood the court's question is that the best of Mr. Orrantia, I think, could do in my experience is he could ask for something to be preserved, but I would suggest that based upon what had happened and what had been recorded in Exhibit A to my motion for remand, that he wouldn't have any reason to suspect that because the video, he was not disciplined because they talked about him having used force and that having been observed. Specifically with issues regarding with count 2 and whether those were preserved or raised, Your Honor, I would suggest that that was raised in a motion to abate because Thompson comes up with that, and I would point the court to United States versus Burke, 633 F. 3rd 984, 10th Circuit 2011, and United States versus Hamilton 587 F. 3rd 1199 2009 that talk about the court can review those, and that wasn't something that was a change in the law that couldn't have been anticipated based upon where it was at. Judge Brattle had asked me and the United States about the defense affirmatively opening the door to the testimony, and I think the issue here in the government has given me something for future trials with this specific contradiction idea. But the problem, and I think the issue that the court, Judge Rattle has hit on the head, is Exhibit 31 doesn't say anything about dishonesty or anything else. And there's an exchange at Volume 5, 680 or 895, and I lost that note, but I believe that's the correct page number, that where they go out and there's a discussion in the hallway between Ms. Ong after she says, what will Mr. Hall testify to? They go out, she comes back in, she represents to the court, it's not in the letter, but Mr. Hall is going to testify that he was dishonest. And then she asks, the court asks Mr. Shattuck, do you have any questions for that? And Mr. Shattuck says, no. I think that, Ms. Ong as an officer of the court has just represented the court what she thinks Mr. Hall is going to testify to. But that's a shifting target where he can just come in and say, he's dishonest. That's not what was in the report. That's not what was represented or anything else. And as I
You could have cross-examined him on that, couldn't you?
Your Honor, respectively, the idea that I would just bring up and enter into more mudslinging with an individual who has just called my client an unsubstantiated liar, I think is something that, as a trial attorney, I would not do because I've raised it with the court, I've lost it with the court, and now I'm going to poison the jury with the idea and allow Director Hall to, and Your Honor, and this is my position, and I think I'm out of time, Your Honor.
All right, any further questions? All right, thank you for your arguments, counsel. The case is submitted. Counsel are excused.
Thank you, Your Honor.
Thank you. All right, next case up is the United States versus Coronado. Mr. Lee.
Good morning, Your Honors. I'm Josh Lee from the Colorado Federal Public Defender's Office, and I represent Jesus Coronado. The question presented in this appeal is whether the police acted within the scope of consent when they climbed onto a roof to retrieve the gun that was subsequently used to prosecute Mr. Coronado. The answer is no. The lessee.
Mr. Lee, can we put this in context? We're here on clear error review, correct?
I maintain that it's de novo review. However, I think I went under either standard. I think it's, I'm sorry, go ahead.
Well, I'm just curious how you think it's de novo. Hasn't the Supreme Court made it pretty clear that even when there's video, that we defer to the district court's factual findings?
Absolutely, and there's no dispute about what any of the facts are. So everybody agrees what was said, everybody agrees the tone and how it was said. The question is what a reasonable observer would have taken from the exchange, and the Supreme Court has made clear that that sort of ultimate question of reasonableness is a question of law review de novo. So when the district court found that it was within the scope of consent, that was an error of law. And if you commit an error of law on the way to making a clear error type of ruling, it's clearly erroneous. Regardless, I think the court should have a definite and firm conviction that the district court made a mistake, and that's so for multiple reasons. The lessee only gave the police permission to go in the home, in other words, to search its interior. The police did not have permission to climb onto the roof. And in addition to that, the lessee only consented to a search for Mr. Coronado, but the police knew that Mr. Coronado wasn't on the roof. In fact, by the time the police had climbed onto the roof, they had already found and arrested Mr. Coronado elsewhere. So let's start with the fact that...
Let me stop you on the second point with regard to permission to search only for Mr. Coronado. In the district court, there was never an argument made that because they had already arrested Mr. Coronado, whatever consent was given had dissipated. Would you agree with that's an argument made for the first time on appeal?
No, and I'm glad you brought this up because I don't think it was as clear in my reply brief as it should have been. I think that that argument is preserved for appeal for two independent reasons. First, Mr. Coronado's objection was sufficient under Street. So what Mr. Coronado said is this search was outside the scope of consent. That put the scope of consent on the table, and all my appellate arguments are doing is building on that objection and detailing why it was outside the scope of her consent, and that's permitted under Street. But setting that aside, the argument is also preserved under Sweet. The Sweet case I've cited, because all I'm doing is challenging the district court's decision on its own terms. What the district court said is this was within the scope of Ms. Valtierra's consent because the roof was a place where Mr. Coronado might have been hiding. It's now fair game for me to say, no, he couldn't have been hiding there. He was already arrested. And that is, the Sweet case says, an appellant can challenge a ruling on a ground addressed by the district court, even if he didn't raise it below. So the district court having ruled, the reason this is within the scope of consent is because he could have been up there. I'm now permitted to say he couldn't have been up there based on the district court's own factual findings. The district court found as a fact, first, Mr. Coronado was arrested, and then after he's arrested, and everybody knows that, then they go on the roof. So I think that is preserved. I think I'm glad I had an opportunity to address it here. That said, you don't even have to reach that issue because the district court also clearly erred in its belief that Ms. Valtierra said anything to manifest consent to a search of anywhere other than the interior of her home. So let's remember, the standard under Florida versus Jimeno is how would a reasonable observer have understood the exchange between the officers and the consenting person? The officers are only talking about being concerned that Mr. Coronado is inside the house. They've already looked everywhere around the outside of the house. They're like, we think he's inside the house. Don't make us send the SWAT team in there. She says, all right, you have my permission to go in there. Under that circumstance, any reasonable observer would say they're talking about the interior of the home. No reasonable observer is going to think, if I give Judge Phillips permission to go into my home to look for something, he then gets to climb on top of the roof. That's not reasonable.
But they came back to her and said, there's a firearm on the roof.
Yes, but she never gave any further consent. So what the order is, she says, you have my permission to go in there. He's not in there. Then they're like, you know, we found a gun, or we see that there's a gun on the roof. She didn't.
They've gone in the basement?
Could they have gone in a basement? That would be a closer case. I think that if.
About the attic?
Oh, yes, I think so. So let me make clear. If the basement is accessible from the interior of the house, and if the attic is accessible from the interior of the house, I think it's clear. Yes, they would have the authority to search that. She gave them permission to go in and search. Instead of going in and searching, they put a ladder on the exterior of the home and climbed onto the roof. I think, if they had gone in and searched like they did in Pena, the government cites Pena in support of its case. I don't think Pena helps the government at all, because in Pena, the defendant says, yes, you can look in the motel room, and they went in and they searched. That's all they did. And similarly, in my case, when she says you can go in, she was giving them permission to go in and search, and that's just not what they did.
What if they had seen someone on the roof?
If they had seen someone on the roof, they could have secured further consent from Ms. Valtierra, or they could have gotten a warrant. But the question is not what the police want to do, but what a reasonable person would have understood from the exchange. Now, if the police had said, look, we see this guy on your roof, and she says, go ahead and search, sure, they can do it. In that situation, they've secured consent to go onto the roof. So they need to secure consent or get a warrant. And when they say, we think he's inside, and she says, go ahead and go in there, the only consent that they've secured is consent to go into the home.
And they saw the firearm with the naked eye, right?
Yes.
And so presumably other people could see the firearm with their naked eye.
Not really, because they had to climb on to a high wall, like a 7-foot high wall, and then sort of shimmy up a telephone pole and shine a light, and then they were barely able to see it. So yeah, I think that the roof is not really visible from the street. I think that doesn't really go to the main issue, which is the fact that they just didn't get consent to climb onto the roof. So I think the locational scope issue is meritorious. The sort of object of the search, that he couldn't reasonably have been found on the roof, that's preserved, and the government doesn't really even fight on the merits of they can continue to search for him after they've already found him. So really all the government has left is this argument that Mr. Coronado does not have standing. But that's just not something that this court can or should address for the first time on appeal. That was something that was raised below. The district court deliberately avoided deciding that issue because it was a tough, fact-intensive issue, and that's something that the district court needs to address for the first time on remand.
Let me ask you about Pena. I mean, you've argued that when we're looking at the district court's decision about the scope of permission, that we review it de novo. But in Pena, we held that we review for clear error the district court's factual finding that the defendant's consent extended to the motel room's bathroom. That suggests to me that we are on clear error review regarding the district court's decision about the scope of consent.
Two responses to that. First, I definitely think we win under any standard of review because it's clearly erroneous to think that allowing me to go in your house gives me permission to climb onto your roof. That said, the fact that the overall standard of review is clear error does not preclude the notion that the district court can make a legal mistake in finding a fact. So what happened here is what a reasonable observer would have taken from the exchange is a legal question, and even if the overarching consent issue is a finding of fact, it's de novo whether the judge makes a legal mistake on the course of resolving a factual issue. That said, I think that the court doesn't even need to decide that because it's clearly mistaken to think permission to go in means permission to climb onto the roof, and it's clearly mistaken to think that consent to search for a person continues after the police have already found that person. Unless the court has...
What makes standing sticky? Why is that difficult when we have testimony about not being a social guest and so forth?
I think that the standing issue is sticky because there are disputes of fact. So Mr. Coronado claims that he was an overnight guest, and in fact, the police admitted that they had intel that he had been staying at that house.
Staying or visiting?
Staying. So the Officer Munoz, who was the supervising officer, testified, you know, we were buzzing that house because our intel indicates that he was staying there.
What was the defendant's testimony on that point?
The defendant did not testify one way or the other on that point. The government claims that he did. That's wrong. What he said is Mr. Coronado's testimony, which the district court found was perjurious, was that when the police arrived that night, I wasn't there, I was at someone else's house. But what the police said is we'd been going by that house because we had intel he was staying there. Mr. Coronado alleged that I'd been an overnight guest there. The government claims otherwise. The district court hasn't held a suppression hearing and hasn't resolved this issue, and it needs to do so on remand. Thank you.
May it please the court?
Counsel.
Counsel. Good morning. My name is Frederick Mendenhall. I represent the United States. Now, the first question presented in this case, Your Honors, is whether, well, a woman gave consent for law enforcement officers to search in her home for a wanted man. And the first question is whether that consent included permission to search her roof for that man. Below, the district court concluded yes, and that conclusion is not clear error, and we are absolutely on clear error standard review here. Just to respond to some of the points raised just now. Mr. Coronado represented today that no one disputes the facts, but he is disputing a fact, and that fact is the scope of consent. And this court has made absolutely clear that the scope of consent is a factual determination. And that's United States versus Pena. Judge McHugh's already brought that point up. Now, today, he also argues, well, there was a legal mistake on the way to that factual determination. But he hasn't identified what that legal mistake is. I mean, here, the district court did exactly what it was supposed to do. Look at the totality of the circumstances and make a factual determination whether the search of the roof was within the scope of consent. And it absolutely was.
I think the argument is that the question of whether a reasonable person would understand go in to mean that you could go on the roof is a legal determination as a predicate to the factual determination of the scope. I think that's the argument.
Your Honor, and yes, Your Honor, I hear what the court's saying, but I think he has it absolutely reversed. You make the scope of consent factual determination, and then you make a legal call as to whether a reasonable person would understand all of that. I think this court's case in United States v. Pena makes clear that we're here on clear error review. But regardless, we would win under de novo review as well.
Let me ask you this. If the issue of whether they could search the roof after they'd already arrested Mr. Coronado is before us properly, don't you lose?
Well, it's not before you, Your Honor, but I'll answer your question.
Well, answer my question first.
Yes, Your Honor, of course.
Can you go in somebody's house to search for a human being when you got permission to search for that human being, when you've already apprehended the human being and therefore know they're not in the house?
Your Honor, I would respond in some cases, yes, you can. And I think it would be very factually specific. I recognize I didn't brief this, but I think there are a couple things that the court...
Well, you didn't brief it because you hung your whole argument on it's not preserved. So if we were to disagree with you and actually be persuaded by the arguments that were made this morning about preservation, you haven't made any merits argument to it, so we'd have to rule against you, wouldn't we?
Yes, we didn't waive it. I agree with that, or I apologize, Your Honor. We did not brief it, but this court can affirm on reasons that I have not raised. I recognize that I'm raising it here on oral argument the first time. I know y'all are not really inclined to listen to these arguments raised here, but to answer the court's question about whether we would lose on that, I think the answer is in some cases, no.
What about this case?
In this case, yes, Your Honor. First, the question turns on the objective understanding of the parties, not subjective knowledge of them. So if one party learns of a subjective fact that actually this person isn't in the house, I don't think that would necessarily change the scope of consent. The second response I have, Your Honor, is that...
Wouldn't a reasonable person understand that I'm giving you permission to search for this person who I've told you is not in my house? And I'm saying you can go in and assure yourself that I am telling you the truth. He's not in my house. You find him somewhere else and arrest him. You think that you still have permission to go in and search your house?
I think, Your Honor, there is some give in this Fourth Amendment analysis. And I think a homeowner would know, okay, I'm giving them consent to search for something. As soon as they find it, they may need time to get out of the house. They may need to, maybe not everybody knows about it. There is sort of a buffer period I would submit to the court that a reasonable person would understand. And in this case, the gun was seized within 20 minutes. And I'd point the court to the analysis in United States versus Jackson, which is in my brief. It's a Fourth Circuit case. I didn't cite it for this proposition, but it talks about a law enforcement officer having consent to search a basement for someone. In the first pass through, they see something suspicious, but they don't check it out immediately. They don't find the person, come back later and look at what they thought was suspicious. And the court said that was fine. I think that's sort of a similar situation here, but I understand I did not raise that, Your Honor. You should absolutely find that this issue was raised.
Is it waived? I mean, was it preserved?
It was not
we
preserved.
We have an argument made, first of all, that it goes to the scope of consent, so that the issue was raised, and this is just a variation on the argument. And we have another argument under Sweet that because the district court ruled about what a reasonable person would understand and held that you could search the roof, that they're able to respond to that with the fact that they'd already found him.
It was waived, Your Honor, and I want to be clear. There were two sentences in the reply brief below about this issue, and it was not this search is outside of the scope of consent. That's not what defense said below. Defense said, and I'm paraphrasing, the consent was for the house, not for the roof. From those two sentences, the district court would have had no idea, no one would have had any idea that they were raising this argument that actually it's not scope of consent, it's whether consent ended. They're completely different concepts, Your Honor. One, the way he raises it is a spatial concern. It's the house, not the roof, not a temporal argument about actually it was over. For that reason, this court should find that it was waived. Now, taking the totality of the circumstances of the consent, which this court looks at in the light most favorable to the United States, the context makes it clear that when Ms. Volterra said, law enforcement officers, you can go in the house, she was giving a broader permission to search for a person, wherever that person may be.
But it was conditioned, or at least it was in mind, the words chemical munitions. We're gonna have to use chemical munitions and blow your house up or potentially damage property.
Yes, Your Honor, those are things that the law enforcement officers did say to her, but it was all for the purpose of finding a person and taking the context in its totality that they were gonna, taking a step back, I think any reasonable person would understand, I'm giving permission for you to search for this man, and if they went inside and the man was there and fled to the roof, the reasonable person wouldn't think, well, my consent ended at the home. They can't go on the roof to go after this man.
But had they spotted him on the roof, they wouldn't have used chemical munitions and damaged her property, right? That's a difference.
I believe that's true, Your Honor. I think they probably would not have used munitions if they had spotted him on the roof. But I'm not sure about that. I think further adding context to this is that law enforcement officers did alert Ms. Volterra that there was a gun on the roof. And at that moment, 30 seconds or so after they'd gotten consent from her that she volunteered, she didn't object. She didn't say, well, you can't go on the roof or you can't get the gun or anything like that. In that position, a reasonable person would absolutely think, okay, this gun, that's not mine. Law enforcement officers have just alerted me to it. By not objecting, it's quite reasonable that they go up there and get the gun.
Why not just ask?
They certainly could have, Your Honor, but they did not do that here.
And so who bears the brunt of that?
No, I think the question here is whether the district court clearly erred in finding it within the scope of consent. I don't think that fact changes that analysis here, especially in the court's cases here. Like, for example, United States v. Pena, the fact that the person did not contemporaneously object to expanding the scope of the search is directly on point here, Your Honor. So it's not something that the United States bears.
Pena is a little different. I mean, it's the bathroom in a hotel room. I mean, you say you can come in and search my hotel room. I think it's pretty easy to see that would include the bathroom.
But not only did it include the bathroom, but the ceilings above the bathroom tile. And as the court analyzed in that case, it was about the object of the search. Drugs could be hidden in the ceiling. A person could be hidden on the roof. Now, I recognize that Mr. Coronado raises, well, they cleared the roof, so he wouldn't be there. But the key distinction there, Your Honors, is that a person is mobile, they can run around. Even if they weren't on the roof at one point, doesn't mean that they couldn't get into the roof later on.
Was there a way to access the roof from inside that casita?
Not from inside the casita, Your Honor. He'd have to go outside. There was
and he'd have to go outside and climb a ladder.
There was a platform.
Is that right?
Not a ladder, Your Honor. There was a platform on the back side of the house from which somebody could climb to get on the roof.
Was the firearm visible to just a passerby?
The firearm would be visible from a neighbor. Now, I recognize the neighbor would have to step up on their property and look around, but it would be visible to a neighbor.
What does that mean? Climb a pole or have good posture?
Something in between, Your Honor. Not a pole. I know that one of the law enforcement officers did, but if I recall correctly from one of the videos, there's like a platform or a standing from which a neighbor could step up on and look over the fence and could see it from that vantage point.
But no community caretaker argument?
No, we didn't raise a community caretaking argument, Your Honor.
Did the drone spot the firearm?
Yes, the drone did, but only after a human being spotted it first.
Is that causal? It wouldn't have spotted except the human being saw it first?
I'm not sure, Your Honor. I mean, the record doesn't reveal that. Here, we do have a human being spotting it, and later on, they had a drone to confirm that.
What if the officers had said, oh, we see a firearm, we caught the guy, we see a firearm up on your roof, and she says, well, I had a firearm stolen, and of course, they're looking for him for a firearm violation, so it's not a big stretch that he might have tossed the firearm on the roof. And they said, we want to go up on the roof. Is that okay with you? And she said, no. Then what?
If she said no at that point, I think we would have to secure a search warrant. Now, if the court finds that the district court did clearly err, we did raise some standing arguments, Your Honor, and they are, I just want to take one. I notice that I'm almost out of time. The cleanest legal issue from which the court can determine standing is that even assuming he was a social guest or a house guest or an overnight guest, Mr. Coronado did not have a reasonable expectation of privacy in the roof of Ms. Valtierra's home. It's a clean legal issue, Your Honor. There are several cases from out of circuit that I cited for the proposition that even house guests don't have a reasonable expectation of privacy in every part of the home. That is an issue that this court can affirm on, and the record supports it, and I would urge the court to do so if it reaches it. Unless the court has any other questions for me, we stand on everything else in our brief, and we ask that the court affirm.
Seeing no questions, thank you, counsel.
I do have a question.
Please.
So why wasn't the standing issue better developed in the district court? At different places in the briefs, it said that the facts were fully developed, but the court declined to hold a hearing. I didn't see a request for a hearing on this issue or a motion that teed it up for the district judge.
That's a great question, Your Honor. Certainly, defense counsel below was very well aware of the standing issues and the briefing that was presented. I would direct the court to Volume 4 on the Record of Appeal, page 663. Defense counsel talks about, I've done some research on the standing issue. He's clear that he says, I'm not conceding this, but I think I'm going to have problems on standing. He says that to the district court judge. Later, at a separate hearing, before he files his reply brief, he tells the court, and this is Volume 4 on Record of Appeal 14 and 15, pages 14 and 15. He asks the court for a continuance on his reply brief. He says that he's talked to some witnesses. It's the homeowner and the sister. And he says, I have my reply brief written. I recognize I'm out of time. I have my reply brief written. I want to attach an affidavit about what they're going to say, but they need counsel before I do that. As soon as they have counsel, I'm gonna attach this affidavit and submit it to you, district judge. District judge says, fine. Curiously, 6 weeks later when he files the reply brief, there's no affidavits filed. I think this is a clear signal, Your Honor, that defense counsel looked into the standing issue and he did not think that there were going to be any facts from which he could present to meet his burden. Unless the court has any further questions for me. Thank you.
Thank you, counsel. Mr. Lee, so I'm not burning your time. Come on up to the podium, but while you're walking, let me ask you to pick up right where counsel left off, which is no reasonable expectation in the roof.
Yes, a couple of things about that. First, I think opposing counsel has sort of confused the record here. The bottom line is defense counsel claimed Mr. Coronado did have standing. He claimed that it was because he was an overnight guest, and he requested an evidentiary hearing to prove those allegations.
Can you tell us where that is in the record?
Yes, give me 1 second. It is in Mr. Coronado's reply. Let's see. Okay, it is in Mr. Coronado's, give me 1 moment. Yes, here we go. It is volume 1 of the record, page 220, is the reply in support of the motion to suppress. And that's where he says, Mr. Coronado was an overnight guest. I request an evidentiary hearing. So he was very clear that he was claiming standing for that reason. Now, the government says,
Can
well,
I
hey,
just ask you one more question? Is that the same motion to suppress which is requesting the Franks hearing, or is it a different one?
it's a reply in support of that motion. So the reply in support of the motion, there's a general request for an evidentiary hearing.
But didn't those only go to the sufficiency of the search warrant? That whole motion to suppress?
No, so the motion to suppress is about the search warrant, right? It says the search warrant's invalid and I have standing.
Right.
So the motion to suppress says both things. We have standing, search warrant's invalid. The government comes back and says, forget about the search warrant, there's consent. The defense comes back and says, no, she didn't consent to this search, and I have standing because I was an overnight guest. I would like an evidentiary hearing. That reply starts at page 220 of volume 1 of the record.
Okay, thank you.
Last thing I want to say, if I may, is you don't even have to decide reasonable expectation of privacy, because going on the roof is a physical intrusion onto the home, and an overnight guest has standing to challenge a physical intrusion onto the home. That's United States versus Bain from the First Circuit, cited in my brief.
Any cases with a roof?
No, but in use check, this court said that going onto the roof would be a physical intrusion onto the home. So if you put use check together with Bain, you get the idea that an overnight guest has standing to challenge a physical intrusion onto the home.
All right. Thank you, counsel, for your arguments. The case is submitted. Counselor excused. Just to alert everyone, we'll probably take a break 10 minutes after the next argument, United States versus Wofford. Good morning, counsel.
Good morning.
Please proceed when you're ready.
May it please the court, Laura Deskin. I'm Assistant Federal Public Defender in the Western District of Oklahoma, here on behalf of Mr. Aiken Wofford. He stands convicted after jury trial of armed bank robbery and additionally of brandishing an actual firearm during that armed bank robbery, resulting in a consecutive sentence. The issue here is solely as to the instruction on the brandishing a firearm count. Importantly here, the firearm can't be a fake. It can be a fake as to armed bank robbery, but not as to the brandishing. That has to be a real one. In this case,
We here under plain error.
yes, we all agree on that, for sure. There was no objection to this instruction. The problematic instruction is that everything was correct in the instruction, except that it said witness identification of the weapon as a firearm is sufficient. And that is problematic here. So does the government have to recover a firearm to get a conviction on this count? No, of course it does not. But just because a witness testifies, yes, I saw a firearm, I believe it was a real firearm, no doubt in my mind, is that enough on its own? It can be, but not necessarily. It's going to depend on how a jury takes that testimony, how they evaluate it, what was the opportunity to observe the firearm, how long. It's completely in the jury's province as to how they evaluate that testimony. So this little
Jumping
line.
through the third prong of plain error, can you show prejudice? I mean, we've got a situation where one of the witnesses is extremely familiar with guns. I think he started being around them at age 2 or something and was able to identify it correctly as a Glock. How has your client been prejudiced, even if we spot you the other issues of plain error?
Well, first, because the weapon was not recovered, we're not 100% that it was a Glock, given everybody kind of said looked like a Glock to me. It wasn't described very specifically in that manner. So yes, that first person who testified.
Well, we have plenty of case law saying you don't have to provide the actual gun, right?
Correct. Yeah, absolutely. But it's
That
not a
witness
given.
Witness testimony is enough for the jury to accept if they find it credible, right?
If they find it credible, it can be enough. It can be.
Okay, we have a series of instructions here that aren't limited to the instruction that you challenge. Don't we have to look at the jury instructions as a whole?
Indeed, you do. And the jury here was instructed as to presumption of evidence, all the typical, the presumption of innocence, all the typical instructions that you would get. Nevertheless, I think that
the instruction you challenge includes within it that the government needs to prove each element beyond a reasonable doubt. And in all the cases that you cite for the presumption cases, not one of them included in the instruction that was struck down a requirement that the government prove each element beyond a reasonable doubt. Do you think that matters?
I think here, this little line that they had at the end overrides all that. If I'm a juror sitting in the back looking through the instructions, I say, okay, yes, they need to prove that this was a firearm, that it has the capability of firing or is able to, and has meets the statutory definition of a firearm, which is provided there. And I read through, and then I see witness identification of the weapon as a firearm is sufficient. I say, oh, well, we did have witness identification of a firearm. That's sufficient. Check. I'm done. That gives rise to this argument here that it undermines confidence that, well, we only have 2 people testifying that they saw a firearm. We have the guy who was very familiar, handled firearms since a kid, but he also testified he didn't focus on the firearm. Everybody was, in the middle of a bank robbery. He wasn't studying the firearm. And I think that's why in other cases where they also didn't recover a weapon, you see, not in every case given, but very detailed testimony elicited describing the firearm in detail. It was a .22, it had a slide, it had this, that, X, Y, Z. In some, they have an actual expert, looking at the video and explaining why they believe that was capable of expelling a projectile by means of action of an explosive.
But Easley's testimony was better than that. They say the question was, or his answer, I'm very familiar with firearms. I had no question whether it was a legitimate gun or not. And it was to you? Yes.
Yes. He said that, no doubt about it. So then it becomes up to the jury to decide, to me, is that enough to determine that it meets this definition of a firearm?
But back to prong 3.
Yes, if it was, is there a reasonable probability of a different result? Well, I would say that there is at least a reasonable probability, because they could have looked at that and said, I understand that he thought that there was a firearm and that she thought that there was a firearm. He'd been around them a bunch. But you know what? I didn't hear enough about that firearm. He said, and we have here the statutory definition, nobody talked about whether this was capable of expelling a projectile or not. Nobody talked about anything but that they thought it looked like
a case where we've required that?
Where you've required
testimony about whether it could expel a projectile by explosion?
No, there is no case on point that says that is necessary, but when you
that would be not plain, right?
Well, I think
even
that
if it were,
it's the reason why it's clear and obvious error here, despite that, is the principle of a jury is not to be misled. And the reason why this jury was misled here is through that very specificity of that it really required just the changing of one word, but that word was important, is sufficient versus it can be sufficient. in your estimation, jurors. It is your task to resolve this.
And I'm not saying this is beautifully written, but you do have to acknowledge the sentence before it has some weight on the sentence that you're contesting. It says, "The government is under no burden to produce the actual weapon or weapons used." And it follows, "Witness identification of the weapon as a firearm is sufficient." In
Yes.
other words, it's okay not to have the firearm because witness identification is sufficient.
They could take it at
If
that.
a witness says so, then you have to believe it.
Yeah, and that's why I highlighted both and like blocked it out in the original brief. I do acknowledge that this followed that. But the argument is, and the concern is, that a juror didn't necessarily have to tie the two together. Yeah, okay, no, they don't have to bring a firearm, true. Witness identification of the firearm as of the weapon as a firearm is sufficient. To me, they could just check that box. We had testimony, end of story.
So I would be more sympathetic and receptive to your argument if this were an issue that was developed in the trial court by a cross-examination or other evidence which discredited the witness's identification. Did anything like that happen in the actual trial?
No, the defense attorney, the trial attorney did, ask, well, could it have been a fake, something like that? And, everybody said, no, I think it was real. I thought it was real. And so it wasn't that it wasn't, in closing argument, they didn't mention it. It was all on, was this the guy who did the robbery? That was the
Let me ask
defense.
you
But it
this,
wasn't conceded that it was a firearm. That was still for the jury to decide
But
ultimately.
it wasn't disputed either.
Also
No, it
had
was
the
not
video,
actively
didn't
disputed.
they?
I'm sorry?
The jury saw the video too, right? I'm sorry. It's hard when we're on different planes. Judge Brattle?
They did see the video, but I think the government would also acknowledge that was very grainy. You couldn't really see anything in that video. But it is clear through the testimony that the robber wielded something that looked like a gun. So I think it matters here especially that an instruction like this not continue to be used. It is different. We have quite a few armed bank robbery cases in the Western District of Oklahoma, and this instruction is out of the norm, at least to what I have seen. And I think that's for good reason. It's not needed in there, and I think when you put that in, that rises to this problem. Well, did the jury think that just because a witness testified to it, that that's enough? And so that's, the point here, and I think that it amounts in this case to plain error. And I will cede the rest of my time. Or not cede it, reserve it.
Good morning, Your Honor, and may it please the Court. Lainey Ellis on behalf of the United States. Plain error exists for a reason. The Supreme Court has called it a demanding standard. The burden is entirely on defense counsel because they did not object. This court in Frost explained that plain error is only found to be at that level when an error is particularly egregious and the failure to remand would result in a miscarriage of justice. And we just don't have that here.
Do we have an erroneous instruction?
Excuse me?
Prong one.
Yes. This instruction did not mislead the jury.
But is it incorrect?
It is not incorrect. This instruction is in direct quote from Sandoval.
But my question on that is, I understand that language is in that case, but that's us talking about a record coming to us. It doesn't say, go ahead and instruct the jury this way. It says, once you have a conviction and there's not a problem, then that's how we look at it. We say witness identification is enough, but that doesn't mean you instruct that way. You instruct down, if in the district court the instruction had said can be enough, then we would still use that same line as our court. We would say it is sufficient. But that doesn't license the district court to instruct a jury that it is sufficient.
I would disagree, Your Honor. While I concede that can be would be better language than is sufficient, it does not make it erroneous.
Well, do you see my point? That the Sandoval language isn't talking about the district court instruction. It's talking about our review.
Correct, Your Honor. It is still an opinion of the court that it is sufficient. But if we lose on the first prong, we still succeed on all three other prongs. Defense counsel first mentioned that it was obvious under well-settled law. That was an issue before this court. And defense counsel has been able to provide no case law or statute that shows that it is obvious under well-settled law. Rather, the favor is in the, it favors in, or it's in the government's favor. This line of, this phrasing is in line with the 10th Circuit precedent of Sandoval, Gregg, Hamilton, and Ruiz, mentioning that a firearm does not need to be present at trial. We all know that. And witness testimony is sufficient.
Is or can be? Isn't can be better?
Can be is better, but is sufficient is not erroneous.
It can be better because it's accurate.
I believe they're both accurate, Your Honor. And when we look at the third prong of the reasonable prong.
Well, let me focus you there for a minute. Is witness testimony always sufficient? I mean, isn't that the implication of is sufficient? That it's always sufficient?
Your Honor, we must look at the context of the phrasing is sufficient. It cannot be viewed in artificial isolation. When it's speaking of is sufficient, we must consider the phrasing directly above it, that the government is under no burden to produce the actual weapon or weapon used. That term is sufficient is going to a type of evidence, witness testimony. It's putting an accurate, correct burden on the government that a physical firearm does not need to be present, but rather witness testimony, a type of evidence, is sufficient. And the witness credibility instruction is also crucial here. The witness credibility instruction goes to say that jurors must review all evidence, but they do not have to determine, or they don't have to say it is factual. They don't have to say it's true. It's up to the fact finder to determine if the instruction or if the firearm was in fact real.
Would you use the same instruction again?
I would not use the same instruction again. But it does not make it, it does not rise to the level of plain error. As to the reasonable probability of prong 3, we clearly have ample evidence in this case. Not only do we have 2 witnesses, one who was very confident that they saw a firearm, we also have witnesses that both explained that it was a Glock, not just a pistol, more specifically a Glock. We have video. I would disagree with defense counsel that it is grainy. I believe that you can clearly see a firearm in that video. And not only did we have the video and witness testimony, but we had still shots from that video as photos to present to the jury. And then as to prong 4, there is overwhelming and essentially uncontroverted evidence in this case. Defense counsel on cross-examination did not raise the issue of the firearm being real, but rather only identity. And when the witnesses explained that they did in fact see a firearm, they were not cross-examined further on that. And as to closing argument, defense counsel only argued at the issue of identity, not the issue of the firearm being real. And with that, if there are no further questions, I ask that you affirm the judgment and sentence. Thank you.
Thank you.
So I'm very glad to hear that the government would not want to use this instruction again, because I would like a ruling that it is at least error. I don't think it's appropriate to use this instruction, and I do believe it is.
Both sides used it.
Well, that's correct. The defense did not see it. It was not objected to, and indeed they submitted an instruction that wasn't on point. So it was, mistakes were made. As to, the plain error issue here. And it's a broad-based principle here upon which I am relying on well-settled principles. The DeSoto case has been part of the briefing, and in that one, the jury was misled by an instruction in a 922G1 case that correctly stated in the jury instructions that defendant's motive for the acquisition of a firearm or ammo is not material to the issue before you. That's a true statement. But the court nevertheless found, the Tenth Circuit, that it was likely that a jury was misled to think that he acquired a firearm, thereby satisfying the central element there, whether he had the firearm. In that case, the government was like, well, big deal, because his theory of the defense was not even that it was justified or excused. So, what difference does this instruction make? But nevertheless, they said, well, in that you said that motive for acquisition is not material. Therefore, a jury could assume from that he did, in fact, acquire the firearm, even though possession was the main thing being contested in that case. And so I'm drawing from that a bigger principle, that juries are not to be misled on elements of defense here, whether or not this was a firearm, even though I must acknowledge that was not an issue in the closing arguments. It was an issue, the defense attorney clearly tried to develop it, but it didn't go anywhere. They just, the witnesses said it looked like a firearm to me.
And were challenged or not? There was no cross-examination to speak of on that point?
I think it was mainly coming from the government knowing that maybe there was going to be an allegation that it was fake, so they brought it up themselves. And did it look like a fake for you? Could it have been? And
with the defense really putting up no opposition on that point, doesn't that bear very heavily on prong 3?
I think that it actually makes this instruction even more important. The jury had to decide whether or not this was a firearm. It was in its province. And it was not led to a conclusion on the firearm one way or another. No argument was made on the firearm. And so it really needed to decide. I mean, that's not an element that was agreed to. That was not an element that was, that the jury still didn't have to decide. And so all it was left with are the instructions. And it looks to that, and when it says witness testimony that the object is a firearm, is sufficient, I think that made it too easy for them to check a box that they needed to think harder on as to whether or not this was truly enough. They could have if this instruction did not state it as such.
Very well. Thank you, counsel, both of you, for your arguments. The case is submitted and counsel are excused. We will now take a 10-minute break before we pick up with the United States versus Wiggins.
Court is in recess for 10 minutes. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you. Please be seated. I see Judge McHugh. And we are now to our final two cases, the first of which is United States versus Wiggins.
Good morning, Your Honors, and may it please the Court. My name is Kathleen Shen, and I represent the appellant, Mr. Brian Wiggins. Mr. Wiggins' sentence should be vacated because his 2008 conviction for Oregon second-degree assault is not a crime of violence because it could be based on merely negligent conduct as an accomplice. The district court's conclusion that the offense was divisible between principal and accomplice liability was wrong. The district court relied on the 2013 Oregon Supreme Court decision State versus Phillips to conclude that the two are divisible offenses, but that wasn't the law when Mr. Wiggins was convicted in 2008. And before that decision, the Oregon Court of Appeals had clearly rejected the argument that juror unanimity was required as between principal and accomplice liability, which is, I think, actually the majority rule. But even if principal liability were divisible from accomplice liability, the Shepard documents in this case do not reveal whether Mr. Wiggins was convicted of second-degree assault as a principal or an accomplice. Under Oregon law, accomplice liability does not have to be separately pleaded, and you can be charged as a principal and convicted as an accomplice. So the mere fact that the indictment, verdict, and judgment form don't refer to accomplice liability doesn't tell us that he was convicted as a principal. He could have been convicted as an accomplice without that being stated in any of those documents. And while the jury instructions could theoretically reveal whether he was convicted as a principal or an accomplice, they're just not in the record. And so the government can't rely on those to meet its burden of proof. And that's a problem because in 2008, in Oregon, you could be convicted as an accomplice so long as the substantive offense that you were convicted of was the natural and probable consequence of your conduct in another offense. That is, if you were negligent with respect to that assault. So that principle derives from Oregon case law. It's clearly stated in the Gibson case, but it's also restated even after the codification of accomplice liability in 1971 in State versus Fitzgerald. And this specific instruction was actually affirmed on plain error in Chapman in 2006, which is just 2 years before Mr. Wiggins' conviction was sustained. And it was reflected in the pattern jury instructions that were in place at the time of Mr. Wiggins' conviction, which this court, of course, may consider when interpreting state law. And so based on the law—
Let me interrupt you. If the pattern jury instruction was not an accurate statement of Oregon law at the time, do we need to follow the pattern jury instruction or what the law actually was?
Your Honor, I think that's a tough question, but I think in this case, given taking into account the state court decision that existed at the time and the pattern jury instruction, when you look at this categorical approach question, which is what does this conviction stand for, what is the least culpable conduct that could result in this conviction, I think you have to take into account the pattern jury instruction, and you have to take into account the state law as it existed at the time, and come to the conclusion that this conviction for Oregon second-degree assault could in fact be based on merely negligent conduct, on the fact that this assault was merely foreseeable, which we know is not enough to satisfy the categorical approach under the elements clause.
But the Oregon Supreme Court has now made it very clear that you don't have to charge individually whether someone is the principal or the accomplice because they're not separate offenses. Correct?
Yes.
And in fact, the Oregon Court of Appeals has found that it's a valid ineffective assistance of counsel claim if someone didn't challenge this very jury instruction. Would you agree with that?
Your Honor, there's Oregon Court of Appeals decisions going both ways on that question, whether or not it was ineffective. And there's also Oregon, I believe, this isn't cited in the cases, but or in my briefs, but in Lizarraga, Regalado versus Primo, they deny summary judgment on the question of whether it would have been ineffective to fail to object to this instruction at around the time Mr. Wiggins was convicted. So there is this there is confusion as to what the state of the law should have been, especially if you apply this retroactivity principle that we generally do apply. But I think if you just look at these cases, first, Hale versus Bilek, which is cited in the briefs, says it was not ineffective not to challenge this conviction. And then, you know, if you look at what actually Oregon courts were doing at the time in around 2006, Chapman affirms on plain error a conviction for second-degree assault, in which this instruction was given, which is another indication that this instruction was commonly in use. And I just think the fact that there are so many ineffective assistance counsel or post-conviction claims from this time period in which this instruction was given, the natural and probable consequences instruction was given, and was not objected to, and particularly including assault cases, shows that there certainly is a realistic probability or that this conviction was in fact based on a finding of negligence, or could have been based on a finding of negligence.
Do you agree with Judge Aiken that we don't even need to look at the actual cases because we can just presume that the law stated in the inaccurate instruction was applied in some cases?
I don't agree that we don't look at the cases, but when I look at the cases that were in place in those time, I actually think they're helpful. So the government relies heavily on this 2004 Oregon Court of Appeals decision and Lauf, where they found there was not sufficient evidence to support accomplice liability in an assault case. But, you know, importantly, Lauf doesn't address the it's not about the instruction, it's a sufficiency claim. The claim that the Court of Appeals rejects in that case is that any conduct by a co-conspirator is automatically sufficient for accomplice liability, which is not the claim we're making here. And I think it's really important that in Lauf, when they're finding there's insufficient evidence, part of their reasoning is that there's no evidence that the defendant knew or should have known that his accomplice was going to possess a knife, which is the conviction at issue there, right? So clearly, even in Lauf, they are applying a foreseeability standard to determining whether there's sufficient evidence to hold him liable as an accomplice. And that's fully consistent with the natural and probable consequences instruction. I think Lauf is actually supports that instruction in a large degree. And, you know, just whatever the Oregon Supreme Court has said more recently about what Oregon practitioners should have been doing in the 2000s. In fact, this instruction was being given and people were being convicted on this theory, and it wasn't rare, and it happened quite a bit. You know, I'd also just like to touch...
If it happened erroneously, I mean, the Supreme Court has actually said that it was settled well in advance, including before this trial, that instruction was erroneous. Does that matter if the jury was improperly instructed? So what I'm asking you is, if we can look at the Oregon Supreme Court case and determine that this instruction was not a correct statement of the law when it was given, how does that factor in to our analysis here?
Your Honor, I understand that the Oregon Supreme Court says that the instruction was wrong and would have been wrong in 2008, and I understand your question. But I think when you look at the purpose of the categorical approach, which is to answer the question of what conduct does this conviction stand for, then I think that has to take into account a real look at what the law said at the time, not applying the legal fictions about retroactivity or what would have been obvious, or taking as gospel what judges might say on post-conviction review when they're trying to determine whether this person should get a new trial or not. At the time, in 2006, it was not plainly erroneous to give this instruction. This instruction and this law, this legal principle that accomplice liability could be based on the natural and probable consequences of your conduct in another offense had been, it was part of the pattern instruction, but it had been reaffirmed by the Oregon Supreme Court, both before and after the codification of the Model Penal Code. And like I said, I think Anloff is fully consistent with the negligence standard. So I don't, I take it that the Oregon Supreme Court now says something different, but if you read the case, they're looking for evidence of foreseeability, and that is consistent with the instruction, and that is consistent with the fact that it was not considered erroneous to give this instruction. And in 2008, the real answer to the question of what were the elements of second-degree assault and could someone be convicted of second-degree assault based on mere negligence, I think the answer to that question is yes, and that renders the offense overbroad.
What do we do about the fact that the Oregon Supreme Court, and we're supposed to follow the highest state court, says that at the time of this instruction, it was wrong, and that everyone should have known it was wrong?
Your Honor, I think what this court should do is look to the categorical approach, which is a principle of federal law, which answers the question of how we determine a historical conviction satisfies a federal definition. And we can't look at the facts of the case because that would put judges in the positions of the jury. So the question we ask instead is what are the facts the jury necessarily would to have found? And the Supreme Court's clear that you look to the law at the time of the offense.
We ask what is the least offensive conduct that could violate the law in that state at the time. According to the Oregon Supreme Court, you couldn't violate it negligently by being an accomplice, and everyone should have known it. Now, you may be right that that's not fair, that everyone should not have known it, but that's kind of what the Oregon Supreme Court has said, hasn't it?
Your Honor, I think that's a legal fiction that we apply when we ask what the law always was, but the Supreme Court's been clear that when we're applying the categorical approach, we look at the law in place at the time. And I think if you look at the motivations and the reasoning behind the categorical approach, which is, again, to remove to look at the conviction and to ask the question, what is the least culpable conduct this conviction could be for, given what the jury necessarily would have found? The answer to that question is that it could be based on negligence. And again, I would point to this court, I think Anlauf, Chapman, Fitzgerald, the pattern jury instruction all support the conclusion that there is a realistic probability that this jury instruction would have been given, and this legal principle would have supported a conviction for Oregon second-degree assault based on mere negligence. And I would point to the court to the fact in Capleton, the Massachusetts Supreme Court does look to the laws that existed at the time, notwithstanding subsequent legal developments. And again, I think, if you look at the Supreme Court's reasoning in Mathis, and they talk about, why we don't just take allegations in the indictment as gospel, but really do this kind of rigid question, they say, look, the defendant may not have challenged that language in the indictment because there would have been no reason to. And I think that same reasoning applies here. This was a pattern instruction. It had been repeatedly reaffirmed, including just 2 years before Mr. Wiggins was convicted in 2008. And the Chapman case isn't cited in my briefs, but the citation is 149 Pacific 3rd 284. It's very much a realistic probability that this is a conviction that rests on negligence, and it would have rested on negligence in 2008, and that renders it overbroad under the categorical approach. And
Counsel, let me switch gear, and if you need a little time, we'll give it because we have a lot of questions on this. But the district court didn't get into robbery, said I'll let the 10th Circuit run that to ground if they think it needs run to ground. It needs run to ground with me, the robbery.
Okay.
And that is to say that he's convicted of first-degree robbery, and to be convicted of that, he has to violate third-degree robbery, Oregon Statute 164.395. And one of the elements of third-degree robbery is the person uses or threatens the immediate use of physical force upon another, which seems like a dead match for the elements. And so why is it not just an easy case that the first-degree robbery counts?
Your Honor, I would point this court to the Ninth Circuit's decision in Shelby. I don't have this at the top of my head because I was really focused on the second-degree assault, but it's well established in Oregon that the use of force or the force required for third-degree robbery is simply purse snatching, and the government hasn't challenged that. And this court, for example, in United States versus Bong, has held that mere purse snatching robberies where there's no violent physical force required don't satisfy the elements clause. And so the third-degree robbery, despite its statutory language, does not satisfy the elements clause. I think that's clear from Shelby, and I'm happy to if there's another case I need to cite, but I think that's uncontroversial and the government hasn't argued otherwise. And the district court hung its hat on the use of the weapon element, but as I explained in my reply brief and in my opening brief, the use of a weapon is not the use of a weapon against the person of another. Of course, you can use a weapon without using violent physical force against another person just on its face. And so for that reason—
So you're saying you can purse snatch while being armed?
You can purse snatch while being armed. You can purse snatch, and after shooting a gun at property, which of course wouldn't satisfy this elements clause. The language of the statute just on its face does not require the gun to be used against another person, and so it doesn't satisfy the elements clause for that reason. I see I'm out of time. Thank you.
Any questions? All right, thank you, counsel.
Good morning, and may it please the court. My name is Paige Hammer, and I represent the United States. The government is asking this court to affirm the district court's finding that Mr. Wiggins was convicted of a crime of violence and therefore is subject to sentencing as a career offender. Unless the court would like to start elsewhere, I'd like to respond to the question that you, Judge McHugh, asked Ms. Shen about whether or not it factors that whether we look to jury instructions or we look to the statute. And you look to the statute. It's very clear when we look through desk camps, Mathis, how this court has viewed the categorical and modified categorical approaches, is we're looking at elements. We're looking at the law itself. And perhaps jury instructions can be helpful when they accurately reflect what the statute, what the law is. But here, the natural and probable consequences jury instruction is not accurate, certainly after 1971. The defense's reliance on the Court of Appeals' case law prior to Lopez-Menjarez, I think, is also misplaced. In Gibson itself, the court said that the natural and probable consequences jury instruction was virtually meaningless, and there were serious questions about its validity. In Anloff in 2000, the court said the exact same thing, questioning whether or not it was even an accurate reflection of the law at any point in time. And in Anloff itself, the court cited Stark, Hightower, Holloway, and Moriarty, all cases that involved sufficiency of the evidence and whether or not there was enough evidence for the jury to find that a person had acted as an accomplice. And each time, in each of those cases, if we look in the language, each time the Court of Appeals' focus is on the intent of whether or not the person being accused of acting as an accomplice intended or facilitated the crime of the principal, and each time the answer was yes. And so ultimately, to conclude in that sense, the jury instructions can be helpful, but they are not the law. The law is the law. And when we're applying the categorical approaches, we must look there.
It is, I mean, I understand your argument, and we have to start with the statute, and we have to determine whether it's divisible, and we have to apply the modified categorical approach. And we have now a Oregon Supreme Court decision that tells us that when this instruction was given, it was not an accurate statement of the law. But as your friend has pointed out, this is the jury instruction under which this man was convicted. So it does seem a little like a bait and switch that we're now going to say, oh, well, they couldn't have found you guilty of an intent that doesn't meet the requirement for a crime of violence because even though they were incorrectly instructed, even if they did. I mean, how do we deal with that here?
Ultimately, Your Honor, the question isn't whether or not this natural and probable consequences jury instruction was given in Mr. Wiggins' state court case, because that is a factual question. And the argument by defense is really claiming legal error in the state court conviction. And what matters is what was the state of the law at the time of Mr. Wiggins' conviction. And here, since 1971, Oregon's accomplice liability statute has required specific intent of the accomplice to promote or facilitate the act of the principal. This court in Dieter looked at something similar within the context of Section 2, which is similar to Oregon's accomplice liability statute. There, this court said that accomplice liability and principal liability are just theories of liability. They are not elements, they are not means. They are therefore not relevant to the first question when we're applying the categorical approach of whether or not the statute is divisible. And so if it's not an element or a mean, whether or not he was convicted as a principal and accomplice is irrelevant. And that is something that this court said in McGuire itself, and that Dieter cites too. So the real question here is, was Mr. Wiggins convicted of a crime of violence by actually applying the categorical approach as it's meant, not digging into the weeds of what jury instructions were given? Was there legal error at the state court level? That's not the question for this court. And
is the statute divisible?
As it relates to the second-degree assault statute and to the first-degree robbery statute, yes. The second-degree assault statute is divisible because when we look at the language itself, there are varying mens rea and actus reus. This court has said that that can be an indicator that it is divisible. Therefore, by it being divisible, that gives us the opportunity to use the modified categorical approach and look at the Shepard documents. And so then the next question is, were the Shepard documents adequate for the district court to find that he was convicted of a crime of violence? And the answer is yes. The information, when we look at first the jury verdict form, it says count 6, assault in the second degree physical injury. So then that begs the question, well, which subsection is it? And then we look to the indictment, and the language very clearly tracks subsection 2. And there's no doubt that subsection 2 requires as an element.
Subsection B, right?
Thank you, Your Honor. Subsection B, there's no question that in order for Mr. Wiggins to have been convicted of that crime, it would require the use, attempted use, or threatened use of force against another. It requires
knowing and intention, correct?
Say again, Your Honor, I apologize.
Knowing and intentional? Knowing or intentional is the mens rea?
Yes, Your Honor, on subsection B and A. C is where the depraved heart recklessness comes in. And so under Oregon law, does that knowing and intentional apply to the infliction of the injury or just the actus reus? And does it matter? I think that makes us go back to Borden, where the against part of the crime of violence language is a mens rea requirement. It's not an actus reus requirement. And so that's where...
Well, it's a mens rea requirement, but the Supreme Court's made it pretty clear that you can have a mens rea requirement that has nothing to do with injury to the person. So I can intend to take the act, but I don't have any intention with respect to whether it injures anyone.
I think I would point the court to...
Sojourn?
I apologize, Your Honor, I missed that last statement.
I mean, we have case law on that. For example, Sojan.
I apologize, Your Honor. I am unfortunately not familiar with Sojan.
Okay, never mind. This wasn't raised, but it seems to me that if there's a problem with this statute in terms of whether it's a crime of violence, that's where the problem is.
I think I would point Your Honor to Capwell. It's an Oregon case that says physical injury requires some form of external violence that produces harmful effect. I think I think implicitly that would mean there's some intent there. It can't just be an afterthought. Your Honor, I think I see I have some time left, though I won't necessarily use it all if I don't have to, unless the court has questions. I would just briefly touch on the government's first argument in its brief regarding forfeiture of the specific argument related to the flawed jury instruction that's now being raised with this court. That argument was not raised to the district court. Certainly, trial counsel for Mr. Wiggins noted this divisibility issue. It somewhat in a perfunctory manner raises the idea of how Tristan may affect the District Court of Oregon case. Tristan affects his client, but ultimately, whether or not this natural and probable jury consequences instruction is appropriately preserved for this court, our position is no. It was never raised.
They argued Tristan, right? They argued Tristan.
They did, Your Honor.
The district court.
But
and the district court discussed Tristan with defense counsel in the sentencing hearing and with the government. And then the district court ruled, and the written order discusses Tristan's reasoning. I mean, in our case law, that's enough to preserve it, isn't it?
As it relates to the divisibility argument, I would agree that there was sufficient record for it to be appropriately preserved for this court. As it relates to the natural and probable consequences jury instruction argument, my argument is no. If the claim that it was appropriately raised, my response is it was raised in a perfunctory manner, and therefore the district court addressed it in a perfunctory manner, if at all. I don't believe that at any point in the record when we look at the filings to the trial court outside of the Tristan case itself and the associated filings of the parties in that case, the sentencing transcript, or the district court's order, I don't believe natural and probable consequences is ever discussed or mentioned. The focus of Mr. Wiggins' trial court analysis was focusing on Tristan for this second-degree assault, whether or not there was an appropriate mens rea, whether or not this recklessness mattered, raised the issue of divisibility between accomplice and principal liability, but the actual jury instruction, as far as I read the record, was not actually raised at all.
Thank you.
Unless this court has any further questions.
I have a question on the robbery. I'm not ready to give up on that yet. The third-degree robbery in Oregon has as an element that the person uses or threatens the immediate use of physical force, which, of course, that tracks 4B1.2. And whether if it's a purse snatching that can qualify, it doesn't say every purse snatching does. The offense, and it needs to be required, it's required to be proved that the defendant used or threatened the immediate use of physical force. It's not taking a purse off of a restaurant table when someone went to the restroom. And so why not? Why is that not fit?
Are you talking about specifically subsection A?
I'm talking about I don't care about any of the first-degree subsections. I'm talking about if you're going to be convicted of first degree, you have to have one of those, but you also have to be convicted of all the elements of third degree. It's incorporated, lesser included offense. And one of the elements of third-degree robbery is that you are convicted of. The jury's told you can't convict this person unless you find that person, beyond a reasonable doubt, used or threatened the immediate use of physical force. And so there may be some purse snatchings that don't, and so what do you get not guilty if you charge this? But some might. And those would be the ones you presumably get convicted of. Why is that not good enough?
I think it goes to the, and unfortunately this is, I guess, isn't contrary to the government's argument, because we acknowledge that that third-degree robbery isn't a crime of violence, because you can commit it in a way that doesn't attempt to use or threaten use of force.
How can you say that when it says it's defined in this, the person uses or threatens the immediate use of physical force upon another person? It's an element.
I think based off of the court's, and maybe I misunderstood the court's question, that I thought the court had said that there was a way that you could commit this without the use of force.
The answer was that, well, that includes purse snatching, so that's not good enough. And my response to that is, maybe it would include you could try to charge a purse snatching, but unless there's physical force, you're not going to convict.
I think I don't necessarily have a disagreement, I guess, with the court's logic there. Our brief, I think.
But the government conceded this, right?
Yes.
The government's conceded it's not a crime of violence.
Based off of the Ninth Circuit case law, I believe we cited, we did concede it. And so.
Storkling?
Pardon, Your Honor?
Is it Storkling?
I would have to look back at my brief, but that does sound familiar.
Oh, okay. No, that's the U.S. case, sorry. I apologize.
Are there other questions for counsel? All right, thank you, counsel, for your argument.
Thank you, Your Honor.
And I'll give you 2 minutes, rebuttal.
Your Honor, just quickly to address the idea that the accomplice liability is never relevant to the categorical approach, the guidelines require this court to consider aiding and abetting liability. Duenas-Alvarez indicates that overbroad accomplice liability can render an offense categorically overbroad. And in 2008, accomplice liability did render this offense overbroad, is our position. As far as the idea that the codification of accomplice liability in 1971 changed the law, in 1974, the Oregon Court of Appeals in Fitzgerald interpreted this precise statute to permit liability for the natural and probable consequences of the defendant's conduct in a different offense, or the cooperating witness's conduct, but they were interpreting the statute and made clear that they did not believe that it had changed the law substantively. And as far as the preservation issue, the whole reason that the district court did the divisibility analysis was because it understood Tristan's point, that if the offense was not divisible between accomplice and principal liability, that would render the offense overbroad. And I would point this court to volume 1, page 43, where the district court considers whether under the categorical approach and due to accomplice liability under the statute, this offense is overbroad. So I think this issue was squarely presented to and decided by the district court, even if we're using slightly different language on appeal. And finally, just on this question about Oregon third-degree robbery, of course, as we well know, sometimes the words in a statute are not interpreted by courts to mean what one might naturally think that they mean. And as the Ninth Circuit reasoned in Shelby, I just had this pulled up, but I turned my page. Oregon third-degree robbery does not require the victim to feel much of anything and can be committed by a perpetrator who prevents resistance by acting so swiftly that the victim does not have time to resist. And that's at 939 Federal 3rd 975. And consistent with this court's decision in Bong, that doesn't satisfy the elements clause, and is why this robbery offense cannot render any error harmless. And so we'd ask for you to vacate the conviction and remand for resentencing. Thank you.
Thank you, counsel, for your arguments. The case is submitted and counsel are excused. Right. The last argument we have for argument today is United States versus Tillman, docket 25-8014. Counsel?
Good morning. May it please the court. I'm John Grevelius on behalf of Conrad Tillman. I will intend to try to carve out rebuttal time this morning, and I'll keep track of my time, of course. I want to start this morning, Your Honors, with the second issue in the briefs concerning the district court's failure to provide a rationale and methodology for calculating the 5-level increase. I start there because the government has conceded error and that it was obvious. So the only question on the second issue is that of prejudice. And this error prejudiced my client. The district court raised the top of his guideline range from 17.5 years to just over 30 years, and this almost doubled his sentencing exposure under the guidelines. Now, such a substantial guidelines jump requires a substantial justification and explanation.
Can I interrupt you and just ask a practical question, which will be nagging at me for the whole rest of your time if I don't ask it now? So as I understand it, defendant is released from custody. He's on supervised release now. Is that correct?
I don't believe that's correct.
Okay. All right. I'll take your word for it. That was my mistake then.
And Your Honor, I can't speak with any confidence on that, but I do know that my client did receive a 30-year sentence. So, I mean, I can double check, but
Right. All right. Thank you. Go
assuming that my client is still serving his time, I will point out that, as I said, that we have to require substantial explanation for such a guidelines jump. And as the government admits, we don't have an explanation of the methodology used. But according to the government, this error is harmless because it believes that the court imposed a variance or would have imposed a variance to achieve a 30-year sentence. But as this court has said time and time again, a district court cannot insulate guidelines error by simply saying that it would impose the same sentence under the 3553A factors.
Can we just take the departure stuff out of the equation and evaluate this case purely under 3553A, or do they not separate?
Well, no, we couldn't, Your Honor, for two reasons. One, because the court didn't impose a 3553A sentence, which I can get to in a moment, but also we have to accept the departure and we have to face that because that's what the court did. And we cannot effectively re-sentence my client or sentence him for the first time on appeal. So I certainly disagree with the government's—
Well, let me just pause you there because I'm looking at the record, Judge Rankin's comments, and he says, I will also take into consideration the 3553A factors as a variance for the same reasons as articulated a moment ago. So how do you say he didn't address 3553A?
My contention isn't that he didn't address 3553A. My contention is that he cannot insulate a guidelines error by saying that he would impose a sentence under 3553A factors. And this remains true even if, for example, he does make findings under the 3553A factors and even gives them weight. We see that from the Burris case, the Pena-Hermosillo case, and the Geiswein cases, all of which I cite in my briefs, which stand for the proposition that a guidelines error cannot be insulated simply because the court says on the record and even maybe makes findings to the effect that it would impose the same sentence. And this court holds firm to that rule for good reason, because as we know, the correct guidelines calculation has to serve as the anchor for every sentence.
Well, I understand that in the context of a court, and we've seen a lot of cases like that over the years, where the court says, you get +4 for leadership or something, and even if I'm wrong about that, why, if this comes back, I'm going to impose the exact same sentence. We say, no deal on that. It's coming back, and you're going to have to find it. But this one seems different to me in that the court goes through the reasons for its sentence, the reason it thought that this deserved a bigger penalty than the advisory guideline range, and then says there's a separate basis I'm relying on, that's the 3553A factors, and the same amount I would go up for the same reasons. In other words, we're not left groping for what would the district court do or why would it do it. It's told us that. has it not?
Well, no, Your Honor, I would dispute that for couple of reasons. First of all, the court clearly wanted to impose a sentence under the umbrella of the guidelines, which is precisely why its focus throughout sentencing, its order, was on Chapter 5 guideline provisions for upward departures. That was where most of the focus was below, both in the arguments of counsel and the court. The court clearly wanted to impose a sentence within the umbrella of the guidelines, and it did not vary because the statement of the reason says it only imposed an upward departure. And as we know, 3553C requires the court to indicate the basis for its what we'll call non-guideline sentence. And certainly here it did not indicate anywhere that it was imposing a variance. So it did not impose a variance. And I think also, back to my earlier point, Your Honor, this does not get the exception that we see in cases like Geiswein, Burris, and Peña-Hermosillo, because again, we can have a court say these things, but it still has to correctly calculate the guidelines range. The guidelines themselves are part of the 3553A factors. So it is an important step, and we can't just have an insulated error based on that statement alone. Now, I want to also point out, Your Honors, because I would be remiss if I didn't address this, the government's argument is also that, well, okay, on remand, all we're going to have to do is send it back to have the court simply explain its 5-level increase. And I do not believe, and I certainly contest, that this idea that there's a 5-level increase is foreordained or inevitable. I say that for two reasons. First of all, based on the rule, the court has to provide a methodology that is tied to the guidelines themselves. And that's either by extrapolation or analogy. And to do this, they have to effectively predict what the Sentencing Commission would have set forth as the appropriate range for that conduct. Now, in the record, we have nothing that suggests that the district court even used a methodology. The government provided no methodology that would have allowed the court to use the guidelines to calculate a 5-level increase. The government never said anything in its briefing below, and on appeal, tellingly, it offers nothing in the record that points to the fact, or points to any indication that the court used a methodology. And certainly probation, for its part, recommended a 1-level upward departure. It didn't provide a methodology to hit the 5 levels. And so I want to give a second reason for this, Your Honor, is I don't see anything in the guidelines themselves, either by analogy or extrapolation, that would automatically lead to a 5-level increase in this case. Consider a slightly different case where my client is also charged with and convicted of threatening M1 with the firearm, directly threatening the firearm such that he is guilty of aggravated assault or assault, either way. Now, under the guidelines, the way that would work, it wouldn't be grouped, but it would potentially add units to his offense if we treated that as a separate offense. But that in and of itself, if you look, I think it's Chapter 3, Section D, if we actually did the math there, you would not get a 5-level increase even if my client had committed a separate offense of threatening M1 directly with a firearm. Now, I don't say that to say that there would be no increase. All I am saying is that the 5-level increase that's supposedly tied to the guidelines is anything but obvious to me. And so, Your Honors, I do think that oh, yes.
I just didn't want you to run out of time before you deal with the first issue.
Okay. I was going to pivot to that.
Okay, thank you.
Okay, well, the first issue is a straightforward case of guidelines error. 5K 2.6 should just not have applied here. In Kelly, this court said that 5K 2.6 does not apply in murder cases because committing a murder necessarily requires use of a dangerous instrumentality, and the Sentencing Commission was aware of this fact and took that into account when setting the guidelines range for murder. Under Kelly, then, it seems that if there's any case in which you can apply this to a murder case, and it quotes 5K 2.0 at the time it existed, it would have to be that the use of a weapon was to a degree substantially in excess of that which is normally involved in a murder. And there were no findings below here that that is what happened. There was no finding, for instance, that my client's use of the firearm endangered anyone else, including M1, let alone that it substantially threatened her more than what occurs in other murders where, of course, murder is dangerous. Sorry.
Is it a fair inference from the court's statements about that it was fired in an enclosed automobile when she was present? Is a fair inference that it endangered her substantially?
No, Your Honor, I don't think that that's the fair inference. I say that because below it was the government's position that this endangered M1, and then that is why 5K 2.6 applied. It actually argued that, and the alternative theory that the court ultimately adopted, which is trauma to M1. It argued both, but the court conspicuously only accepted the trauma aspect, and it never found specifically that she was endangered. And we would certainly need that finding because that's a finding of fact that we cannot make here on appeal.
Didn't the court recognize or say that perhaps in this sort of a situation, once you put things into this kind of motion, maybe the young girl would try to intercede in behalf of her mother and become injured in that fashion?
Well, the court never made that finding, Your Honor. That was the government's position that perhaps she could have intervened or crossed the line of fire. The government did couch its language in terms of what could have happened, but there was no finding whatsoever that that was the basis. It was clear that the court imposed this departure for the reason that that the firearm was discharged, it said that twice, and that it was fired in an enclosed vehicle in her presence without justification. So none of this is really addressing.
Is it your position that it's ambiguous whether the court decided it based on trauma to the minor or substantial danger to the minor?
I don't think it's ambiguous in the sense that I think it's clear the court did not adopt the endangerment theory. Now, whether it was adopting trauma, I think that's a little closer of a question. If you read the whole sentencing transcript in context, it kind of refers back to its original discussion about why it was departing under 5K 2.0, which really kind of encompassed trauma to M1. But I think, yeah, perhaps it is ambiguous what exactly, whether between firing the pistol or trauma to M1 or just the circumstances, but it never found that she was endangered and that that was the basis for applying that departure. And Your Honors, just briefly, I want to touch on this. As I've argued in the briefs, trauma can't be the basis for 5K 2.6 to apply. That's covered by other departure provisions. And I'm certainly not telling this court that her trauma doesn't count. Indeed, I'm just saying that it doesn't count twice because the court did use that under 5K 2.0, and we have not challenged that on appeal. And Your Honors, unless there's other questions, I would like to reserve the balance of my time.
Very well.
Thank you.
Good morning, Your Honors.
Morning.
My name is Cameron Cook, and I represent the government in this case. I'm here to answer any questions and explain why the district court got this case right. The first issue I want to address is...
Well, I want to stay where we were on the trauma versus danger issue. If we look at our case in the United States versus Eddington, we make it pretty clear that it's not our role to make factual findings necessary to support the imposition of a sentencing enhancement. And here, I mean, I don't think the court made a specific finding that it was applying 2.6 because 5K 2.6 because of substantial danger to the minor. And it talks about trauma quite a bit. Do we need to send it back to have the courts make a finding and tell us what the basis of this was?
No, Your Honor. The finding was that 5K 2.6 applied. So I will agree that the district court didn't go into details on, because if you read 5K 2.6, it says possession or use of the dangerous weapon, and then it says the extent of the increase may depend upon the dangerousness, manner of use, and the extent to which it endangered others, and then it finally says a discharge of the firearm may warrant substantial increase. So the district court didn't explicitly say where in there it was basing its reasoning mostly, but it did find that it applied, and its reasoning that the firearm was used in a confined space in the presence of M1, I think it's fair to read that reasoning as endangerment, as the manner of using it in front of M1, and all these knock-on effects of the trauma that she would experience later on. So I do think there was a sufficient finding under 5K 2.6 here.
But there's no specific finding that says he endangered, substantially endangered the
That's correct,
minor.
Your Honor, and that is not in 5K 2.6. So I don't think it's necessary. But yes, the district court did not make that specific.
What do you mean it's not in 5K 2.6? I mean, 5K 2.6 says when it's appropriate to impose it, and it, as you indicated, has as one of the factors endangerment of others, discharge of the gun. But the court didn't tell us why it decided to impose 5K 2.6. And I guess your position is you can infer it?
Your Honor, yes, reading it fairly, the district court did say, because it used it, again, the manner, using it in front of M1 without justification in the confined space of the pickup. This was a very narrow compartment in which it was fired. The evidence of the sentencing hearing from the defendant himself was that the victim was on her hands and knees attacking him while he was still driving the vehicle at night on a highway, and that basically she hit his arm and the gun went off. And so when you add that context of the record to what the district court did say, I do think that's sufficient under 5K 2.6.
Well, isn't that having us make the finding? Looking at the evidence and making a finding?
I disagree, Your Honor. I think the district court did make the finding on 5K 2.6. I think they could have been a little more explicit, but it addressed the manner of use, and again, confined space, the fact that she was there, that's inherent in describing the circumstances of when the shooting, how the shooting occurred.
It's also inherent in her being traumatized, right?
Yes, Your Honor. That's the easy and obvious knock-on effect of using the firearm in front of her.
So, I mean, I guess the argument is that we don't know whether the court was using those facts to support a finding of trauma or a finding of dangerousness.
Well, again, Your Honor, I disagree. The provision says manner of use and the extent to which it endangered others. Again, the district court said used it in confined space in her presence. I think that's sufficient for what the departure says. Your Honor, we're really drawing the line there on, I understand the ruling of Kelly, but I just point out the district court in Kelly dealt really with a record that had just the bare use of a dangerous weapon in private. Here, we're drawing the distinction based on the use of the dangerous weapon in relation to a third party, which is not inherent in murder as charged. So there's nothing inherent in there, and for the reasons we put forth in the brief, it does elevate this away from the heartland, so we think it was proper here. Unless there are any more questions about Kelly, I would like to turn to prejudice. Judge Phillips touched on it, but this is the key factor for understanding why there is no prejudice in this case. There was no error in the jumping off point for the variance. As Judge Phillips talked about, there are some cases where the district court erroneously applies a 2-level, 4-level enhancement, reaches an improperly high guideline range, and then varies off that point up above. Here, the initial calculation was an offense level of 35. That's second-degree murder, 38 minus 3 for acceptance. And then the district court departed upward 5 levels, but also varied upwards 5 levels to reach the same conclusion. So yes, the departure was erroneous because the district court did not explain why he departed. But the variance was not affected by that error. It was independent and not tainted. And as we argue, the district court's variance was thorough, cogent, and supported by an exhaustive record. The defense in their brief repeatedly calls the district court's variance perfunctory. That is simply not accurate. It's worth stating on the record that the district court started his imposition of sentence by acknowledging the defendant's apology, both at sentencing and after the crime had occurred. The district court described the circumstances of the offense. He described evidence of the defendant's past abusive behavior, which was testified about at the hearing. It commented probably the most significant factor other than UT losing her young wife at age 36 was the presence of M1 in the back seat. The district court questioned what things would look like for her in the future. The district court acknowledged and considered the defendant's statements, the defense investigation, and the victim impact statements. It addressed the departures, and then it made specific references to the Section 3553A factors, including the nature and circumstances of the offense, which it had already discussed, but also commented on bruises to UT's face and lips, preceding the firing of the gun, the physical harm and name-calling to M1, the use of a firearm. The district court called this crime senseless, unnecessary, and cruel, and that it resulted in tremendous loss to the entire family, but particularly to her children. The district court commented on the history and characteristics of the defendant. He referenced his power and control and anger that culminated in UT's death, commenting this is seen in his relationship with Bear Comes Out, who testified at the hearing, and UT over the years. The district court acknowledged the lack of countable criminal history and that he's done good in the community, but here he did more bad than good. He commented that he'd already discussed the seriousness of the offense, the need to promote respect for law and provide a just punishment would be shown by the ultimate sentence imposed. The district court emphasized the murder was completely senseless and driven by some sort of percolating anger that was taking place on the day by the defendant. And then the district court commented on the need for deterrence and protection of the public, and stating without addressing these anger, power, and control issues, the defendant is a danger to society. He commented that the defendant committed this murder in front of his daughter with very little provocation. After all that, the district court departed upwards, and then also the language that Judge Phillips referenced earlier took into consideration the 3553A factors to reach a variance which was reasonable and appropriate under the facts of the case. And Your Honor, all that was supported by an exhaustive record. I'm not going to go over it all, but we had the case agent testify about evidence. We had Keyshawn Bear Comes Out testify about the defendant's past abusive behavior, both to him and also UT. And then there was an expert who testified about the gunshot and had his report entered into evidence, basically that UT was looking away and down when she was shot in a defensive position. And then the defense also put on evidence, and the defendant himself testified, gave his version of events, which is a little unusual. They also had an investigator testify and provide a number of exhibits that they thought was mitigating. So this all provides context to the district court's analysis of the factors, and it shows that this was a thorough and cogent variance, unaffected by the error.
Can I ask a question about that? So you started this part of your argument by saying that there was no error in the jumping off point for the 3553 analysis?
Yes.
Which I take it to mean you're saying there was no error in the guideline calculation which prompted that analysis. Is that your position?
Yes, Your Honor. The initial calculation of 35. 35 was the initial offense level calculated, and from there, defense requested basically a low-end guideline sentence, and the government and the district court went with an upward departure and an upward variance.
But so you're saying that a jumping off point was before the departures were applied? There was no error in that?
Yes, Your Honor.
Okay, but so that's not inconsistent with your concession that the district court failed to adequately explain its degree of departure?
Yes, Your Honor, because the departure comes afterwards, and we admit that was error not explaining it, but we had this separate variance which was thorough and cogent and was unaffected by the departure error, is our argument.
Did the government go through the 3553A factors in particular?
It did, Your Honor, both in submitting, definitely in the briefs that were submitted in the sentencing memorandum that was submitted before the sentencing hearing, the government addressed those factors. That'll be in the record. I'm unsure if I specifically addressed each of those at the sentencing hearings, but there was an argument made, and I did reference to the sentencing memorandum, which definitely did address those factors. Your Honor, lastly, I would just note this case is lacking a lot of the other errors we see in other cases. There is no factual error committed by the district court, such as in the Guevara-Lopez case. There's been no showing that this is an unwarranted disparity for murder cases, also in Guevara-Lopez. As argued, this wasn't a perfunctory statement that, I just would have imposed the same sentence anyway. The district court didn't focus exclusively on one factor, like in the Crosby case. Here, the district court talked about mitigating and aggravating evidence and multiple 3553A factors. And then as argued, that guideline range error wasn't, the starting point wasn't affected by that. That was just a departure. So, Your Honor, looking at the record in this case, whichever standard of review we use, either preserved or plain error, it's clear that the sentence the district court would impose would be the same without the error. So unless there are any further questions, I would ask the court to affirm.
Thank you, counsel.
Thank you, Your Honors. I'm going to start with prejudice. The question here isn't whether the district court made findings that were relevant to the 3553A factors. The government's argument that this can be affirmed because the court made what it calls extensive findings on the 3553A factors doesn't get off the ground under this court's decisions in Burris, Peña-Murcio, and Geiswein. In fact, the only case that even supports the idea that this type of, well, I would impose a 3553A sentence regardless, actually came in Geiswein, but that was only because the district court had previously sentenced the defendant to what was the stat max in that time. The court had said it intended to pose a statutory maximum, and it had said clearly, or it made clear that it intended to pose a sentence outside of the guidelines themselves. We do not have that here. The court was clearly intent on imposing a guideline sentence, which is why it spent a lot of time, the substantial amount of time, trying to justify the sentence under Chapter 5 in the guidelines. And so I do not see how the government's argument gets off the ground under this court's precedent.
Well, the court addressed the parties' contentions. It's not like the court was just sitting there by itself and came up with these departures. It was proposed to the court, so the court addressed them.
Well, I mean, that may be true, Your Honor, but we are stuck with what the court said, and the court did impose departures under Chapter 5. Now,
did the government offer any methodology for explaining the degree of the departures?
None whatsoever, Your Honor. And I would be remiss if I didn't talk about just briefly, although it's again my position that this isn't dispositive, but the district court did not make the exhaustive findings on the 3553A factors that the government contends. It didn't discuss general deterrence, which in Crosby, this court said, is one of the key components of sentencing. And it didn't talk about sentencing disparities whatsoever. And it didn't provide any sort of, any explanation to how it was weighing these and why the weight of these factors justified such a large jump in sentence. So, Your Honor, I do not see how that this error can be harmless under this court's case law or under the facts of this case. And I see I'm basically out of time, and I therefore ask that you all reverse. Thank you.
Thank you, counsel, for your helpful arguments. The case is submitted. Counsel are excused. The court stands in recess until 8:30 tomorrow morning.